Just a reminder to everybody that we are recording today's webinar. So thank you very much for attending. Just wanted to let everybody know that. So thanks for joining us today. Looks like the weather's starting to shift a little bit. I'm getting a lot of notice of cancellations and things like that for this afternoon. I think a live on 25 was canceled. So hope everybody stays dry. But what we are here to talk today about is really interesting topic that Courtney helped put together. And that's that we hear so much misinformation about estate planning. We often hear things like, my friend said do this, or, oh, this worked for my neighbor, this worked for my in-laws. But look, estate planning is so incredibly tailored to what it is exactly that you need that it's really hard to say that. So what I often find people have is actually also, oh, that won't work for me. Because of some misconception about what estate planning is and what the options are. So the thought process behind this webinar was to talk about some of these myths and kind of debunk them as we go and see how we can help. So just a couple of just housekeeping items. We have first, that nothing that we're talking about today is legal advice. Okay, so what we're going to be talking about today is what we call legal information, right? So these are some general concepts, myths of estate planning, but I highly want to make sure that you do not do anything as it relates to what we talk about today, because we have to apply those things to exactly your specific circumstance and make sure that that you're covered and you're addressing all the possibilities and all the intricacies of the estate plan. And naturally, so there's no attorney-client relationship, obviously, founded by this. This is purely for your information only, and I hope that you truly do find that. Now, just everybody knows you're in the audience, you're in listen-only mode. You can see our slides. If you can see our slides, just do me a favor, just put a Y into the chat on the bottom of your screen. So that allows me to get some feedback from you, because you are in listen-only mode, which means we can't see you or hear you. So I am talking to a camera, and so it's helpful to make sure that I know everybody is there. Fantastic. Thank you. Hi, Mary. Thank you. Fantastic. Okay, great. And so we are going to save some Q&A today and save some time to be able to answer your questions. I think that's very helpful, and I hope that everybody takes advantage of that, because I'd love to be able to help you out. But listen, don't put any confidential information into the chat or into the Q&A. What we are going to do is use the Q&A. You'll see in the bottom hand of your side of your screen there that will allow you to put a question in. Now, we're going to save the questions for the end, but what I would recommend that you do, so you don't forget, like me, I would put the question in as we go, and we'll accumulate those questions as we go through the materials today. And what will happen is Courtney will go through those questions at the end, and we'll go ahead and answer them for you. So looking forward to that. So let's dig in. So what are some of the most common myths that we hear from clients or prospective clients or just out there on the street? The common things we hear, for example, are things like estate planning is only about the money, right? It's only about the finances. And naturally, with that same line, right, another misconception, another myth is that estate planning is only for the rich and famous. That no, my estate isn't big enough. I haven't accumulated enough assets. I can't tell you time and time again how many times I sit with the clients and they say things to me like, well, I don't have all that much. Some might not consider it that much. And when we look at it, it's like, well, some might not consider it much, but some may consider it quite a lot. Right. So this idea of, oh, I don't need to start to plan because my estate isn't big enough. And in that same idea, another myth that we'll tackle is, well, have I waited too long? Am I too old to do this? Or am I too young to do this? And that really ties into this talk about that, estate planning is not just about the finances. Another myth is that you can or cannot disinherit anyone that you want to during the estate planning process. Are there specific people that have to inherit money? And we'll tackle that one. Another common myth that we hear is, do wills avoid probate? And we're going to tackle that answer as we move through the material, and we'll see if the answer yes or no to that. And finally, another myth is that just all trusts will help us avoid estate taxes. And well, believe it or not, we're going to tackle that one as well. So we got a lot here to unpack today. We're going to hit a lot really quick. Try to dig in as much as we can. As I said, please do go ahead and put any questions that you want to have answered into the Q&A, we'll be glad to go ahead and get those answered for you. So this webinar is for you if you're just not frustrated about knowing the truth, right? So if you've heard some of these things, right, from someone who's not really an attorney, and you just don't know what's accurate, what applies in my situation. And so much of what we do here at Cheryl Law is to help people protect their assets, protect their home, protect the legacy for their family. So, if that is something that you are looking to do, this is a good webinar for you, so that way you can learn about some of those options. And this is also good for you if you don't want to leave a mess behind, because a lot of these myths, right, can lead to a messy estate, which only makes it more complicated, more difficult for your heirs to inherit your assets, sometimes having to go through lengthy court proceedings such as probate, and sometimes just leaving downright mess in terms of beneficiary designations in different places. So we like to try to clean those things up. So just before we dig into everything, just a little bit about me for those that we haven't been acquainted yet. As Courtney said, I am the founding attorney of Cheryl Law PC, and we are an estate planning, elder law, trust and estates law firm here on the East End of Long Island. We dedicate our practice to helping people plan and protect their assets and transfer those assets to their intended beneficiaries, preserving a legacy for those that they leave behind. So this is me and my wife when we were little kids. She's with me today, not here at the webinar, but this is why I do what I do, because it's for me all about family. We are here because we have our parents, our families that worked hard and established a life here in this country for both of us, and we like helping families continue that. And the ability to plan and protect money for your children is one of the most beautiful things that you can do in this country. And what we do helping with clients is help them so that way we don't have to write unnecessary checks to the government, voluntary contributions, if you will, by simply not having planned, maybe fell into some of these traps, these myths that we're going to get into. And how I got started in this area of practice was I had been actually working as a traffic cop here. And I went back to school to get my education so I could be on the civil service exam list. And I had taken a class in criminal law. And in that criminal law class, that was the first time that I had ever studied something that just felt like hours went by in a matter of seconds, right? And so I knew this was something that was a passion for me. And I knew if I was going to devote a lifetime to it, that I really need to be connected personally with our desire in terms of protecting assets for people. So I took some more classes, learned more about different areas of law, did some different areas of practice before starting this firm. But when I did start this firm, I had now become married. We had our first daughter. And, it was just, I started to see the idea that really what we get to leave behind is not necessarily the money, but the money that we get to leave behind for our families. So we work with families to help them protect assets. At this time, I had just got a job building someone's an estate planning practice, but I had just thought there's a better way of providing the services like we do, which is to hold our clients' hands through the entire process and really not make decisions for them or pull a cookie cutter approach to an estate plan, but really work with highly tailored estate plans with clients that are looking to protect assets. And so when my second daughter was born, this is Lily, when she was born 2 months premature. This is her in the hospital. And it was just an eye-opening experience to see how fragile life could be. And so at that time, I went ahead and started my practice, and we figured this was a good time to get it started and helping people in the way that I knew best to help, and not in some of the ways that we see other attorneys' offices helping clients through estates, whether they're not dedicating their time to it or operating solely as mills. We just thought there was a better way. And this is them now recently, well, actually about 2 years ago at this point. I got to get some new updated pictures. They keep growing. And so this is why I come to work every day and why I want to help everybody do what we do. So look, the laws are complicated. And so we are talked about this. There's a lot of myths and misconceptions, and not knowing them often will cause inaction or you to take the wrong actions, which will be counterintuitive to your plan, often incurring more liability. Maybe we're saving money from capital gains, but making a Medicaid liability. Maybe we're not preparing a will and changing a beneficiary, but now there's no protection for that beneficiary if we have they've been disabled. And so we want to make sure that we can kind of clear that up for everybody, that there's there's this incorrect information is resolved, and really giving people the answers to the questions that they want. And we've really seen families worry turn into relief. So let's just dig into the first myth. And the first myth that we often hear people say is that my estate plan is only about the money. Now this just really isn't correct. Money is definitely a big piece of it. But as I said before, money is a vehicle to something, right? The money doesn't necessarily do anything. If I have money sitting in the bank, it's make me a sense of security, but it doesn't do anything just sitting there. That has to do with legacy, right? And this is what people can do with the money. But even beyond that, though, it's not just about money. One of the key important parts of an estate plan is what we call advanced directives. And that would be making your wishes known about your healthcare treatment. If you were disabled, if you were incapacitated, you were not able to manage your finances, you weren't able to make healthcare decisions. In those events, it's really important to have what we call advanced directives. Common advanced directives are things like powers of attorney, healthcare proxies, living wills. And we'll talk about some of those things in the next slide. But with that estate plan in place, you get to pick control. And really, that's, if we really want to sum down what a estate plan is all about, is about control. By making decisions on your own through your estate plan, through powers of attorney, healthcare proxies, living wills, trusts, wills themselves, you get to take your decisions about your life into your own hands. Because if you don't make these choices for yourself, the state will make them for you. The state of New York has laws about what happens where you don't make your own decisions known. And they're not exactly going to line up with what your values, your beliefs, your wishes will be. So one of the best things that you can do, besides having taken care of your advanced directives, is to maintain the control, because you get to maintain the control and say what happens, that your wishes will be honored when you pass away and not what the state says should happen. So, for example, some things that we deal with that are beyond just the finances of estate planning would be long-term care planning for home health aides and nursing homes. Now, often these will go hand in hand with some money, but part of the estate plan is setting ourselves up to make sure that we can age in place if we'd like to be able to, which I think every single client we have ever spoken to wants to age in place. And that would be to get home health aides at home. Now, the cost of care for home health aides currently runs about, I'd say about $5,000 to $10,000 a month, depending on how many hours a month that you're using. For example, if we're just using someone for an hour a day, that's going to be a lot less than if we're doing a 24/7, 365 live-in. And then nursing home care is another big component of what we do in terms of estate planning, is to secure nursing home care while protecting minimal assets or more assets. So that way a person's not left completely impoverished by the cost of nursing home care, which can run upwards of $16,000 a month. So that's one component of it. The other component of the estate plan we talked about was these healthcare documents. For example, getting a healthcare proxy in place will allow you to appoint an agent who can make medical decisions for you if you can't. If you're incapacitated, you can't make your medical decisions anymore. If you haven't made this election, the state's going to have a priority list of who can make decisions in only very limited circumstances. That's limited to hospital stays, but not this discharge planning. And so here you get to choose, right? And I mean, even in that list of the default people who can be your healthcare agent, it starts to list things like a close family friend. I mean, if you're incapacitated, you have no say in this at this point. You can't say, well, I didn't like that person. We were barely even friends, right? This is where you get to make those decisions. Another common estate planning document that doesn't really deal with finances is what's called a living will. And a living will is a document where you get to make your wishes known about end of life treatment. So what is end of life treatment? This would be, for example, a scenario if I was a permanently vegetative state, permanently unconscious, no chance at recovery. I'm unconscious, let's say I'm intubated, ventilated, right? And I have no expectation of recovery. My living will would say that I don't want to be kept alive in that condition artificially. Right. The only thing that's keeping me alive at that point is the mechanical respiration, the artificial nutrition. I wouldn't want to be kept alive by artificial means if I had no chance at recovery. So I'm not able to make those wishes known at that point naturally. So what people do is part of their estate plan is to execute what's called a living will that says, well, I'm in health now, I'm in good health now, and I have capacity, and I'm making my wishes known about that end of life treatment. I do not want to be kept alive artificially if I have no chance of recovery. I would like to be kept alive only if I do have a chance of recovery. For example, I wouldn't want invasive procedures. I had a client where we fought for this because they had a living will. The hospital wanted to amputate their leg because he had been developing really bad diabetes and bed sores from his leg, and they thought that that would prolong his life for about a week. But he had no expectation of recovery. He was unconscious. And we thought, putting him through a surgery to amputate his legs in the last 2-3 weeks of his life just didn't make sense. But what was critical there was his intent had been put in place years ago before the need arose. So these are some of the many ways that estate planning is not just about finances. So debunking myth number one is estate planning is not just about finances, because there are so many other components of the estate plan that we have to be aware of that deal with your person, your personal needs, your healthcare decisions, your wishes about end of life treatment, your decisions about who can have be the person who plans your funeral. These are really key decisions that you get to make that you shouldn't leave up to chance. And so, no, estate planning myth number one is not correct, that estate planning is so much more than about finances. But in that same vein, estate plan myth number two is that my estate is not big enough. And I think we already know that we can debunk that myth real quickly, because we just said that the estate's not about the money. I mean, sure, it does help. And we can do a lot with protecting assets. We'll talk about some of those things. But regardless of the net worth, there's a lot that we can do about leaving our assets to our beneficiaries and also preserving assets. One person might say that I have a house, $100,000 in savings, and that's a lot, or that's a little. It's all subjective. I might have a client that has $2 million, a house, $3 million, and they say, I got barely anything, right? It's all subjective. At the end of the day, you've worked hard for the estate, whatever it is that you've built up. You should get to choose who it goes to, and you should get to protect as much of those assets as possible. We don't help anybody do anything in terms of tax evasion or evading Medicaid liability, but working within the rules that you do have for each of those programs, knowing your rights to preserve money. If we don't utilize the rules that we have to preserve money, then we're just voluntarily writing extra donation checks right to the government. And I don't know about you, but our firm belief is that the government already taxes enough. We don't need to write voluntary taxes, voluntary checks on top of those amounts, and they don't quite spend it that well as it is. I think that those funds would be better off in your family's hands. Now, an estate plan is not just for the rich and famous. For example, just having a bank account, owning a home, an estate plan is necessary. For example, you have a home, right? You have a bank account. If you don't choose your beneficiaries, who's going to get it? The state will choose for you. One of the most common misconceptions that we see, or disconnects between one of those default rules that I talked about, the state choosing for you, is where we have a spouse and children. For example, if I'm married, my wife, and I have 2 kids, I showed you earlier. If I don't have a will, the state's going to say that my children are inheriting about half of my estate. Now, that's not what I would want, because I'm married. I want my wife to get a half. I don't want to get a half. I want to get the whole thing. I don't want my kids to get anything. Besides, my kids, I showed you the picture, they're a little older, but they're 6 and 5 right now. I don't want them getting anything. I want the money to go to my kids, to my wife, and only to go to my kids if something had happened to both of us. And that's a really great point. So if I didn't have a will, the money would go to my wife, about half. The other half would go to the children, and my children are 6 and 4. And I wouldn't want any of that money to go to them, because they're minors and they can't maintain that money. Someone would have to go to court to get access to that money. It could really easily eaten up even the minor amount of planning, even the minor amount of assets, if we haven't planned properly, because now the court expenses of having to go through court custodian proceedings to be taking care of money for minor children, whether this be children or grandchildren, it's a problem. So by you having your estate plan, you're taking the necessary steps to make your wishes known, and you can craft in a plan fairly easily around some of these big pitfalls that can just be drains on the assets that you have. Now, I always tell everybody this, and Courtney knows, right? Everybody has a plan, even if you don't have a plan, because the state is going to make those decisions for you. So you just don't know what the plan is. You don't know what's going to happen. But you know it's not going to be your choices because you didn't make those elections known. Now, part of the estate plan is also keeping your estate and your personal needs out of the court's hands. And this is what we call guardianship proceedings. And so between the healthcare proxy that we talked about before, as well as the power of attorney, which is a very, very important document to have as part of an estate plan, we want to have those to be very comprehensive to keep your decision making out of court, even while you're alive. So that way you have that authority vested in who you've chosen to be able to make your wishes executed, your healthcare decisions, your finances managed. I'll give you an example. We often see this come up even during lifetime. This estate planning doesn't just start at death, as we've talked about so far. We've seen this come up where someone has suffered a stroke, for example, or has had an onset of dementia and Alzheimer's, no longer has capacity to make their wishes known, to handle their finances, to pay bills, to make their healthcare decisions, arrange doctor's appointments, shop, do all their what we call activities of daily living. And what happens in those cases will be usually where they haven't planned in advance. We'll come into our office, we'll meet with them and determine that the parent, the mom, the dad, the client does not have the ability to engage in estate planning at this point because they've waited too long. And what has to happen in those cases is we need to go ahead to the court to get power to start to make an estate plan for them. Now, we're pretty limited in what we can do, but it's certainly something. But because the wishes weren't made known, the power of attorney wasn't prepared, the healthcare proxy wasn't prepared, we're left having to go to court in order to get those powers given by the court. Now, there's a big difference, though. When we have power of attorney or a healthcare proxy, you're not losing any authority by signing those documents. You're just delegating it to someone else who can act for you when you can't. But you don't lose anything. So, for example, if I sign a power of attorney over for my wife, I want to be out of state for a second, I want to be able to sign an agreement for me, do something at work, I can do that. I haven't lost my ability to act, though, on my own. But when you have a guardianship proceeding, right, most often the result is that the court takes away power from the person who's incapacitated, declares them incapacitated, what we call a ward of the state, and then the court will appoint either a person, maybe it's one of your family members as guardian, but often can be a third party, someone who you've never even met, someone off a list called the Part 36 list of volunteers, although they get compensated in many cases from your assets. They will be appointed as a guardian for you. Now, I'm not to say we have to be afraid of guardianship if it's truly needed, but we should know that we can plan around it. I think if I took a survey from any of our clients and said, would you rather pick and choose, sign a power of attorney, sign a healthcare proxy, or go through a court proceeding when you're incapacitated, have the court take those powers away from you, they would agree we'd like to plan ahead. Okay. And so by doing a comprehensive estate plan, you get to leave the legacy behind for you, for your family. Now, in this same vein, one of the myths that I want to mention is also that it's too late to do estate planning. And this is just a complete misconception. We often hear this be, well, I'm too late to the game. I hear this a lot from tax planning perspective, and I hear this a lot from a Medicaid planning perspective. And the answer is it's really not true. I mean, we have a lot of options we can make. Sure, the best options that we can do to protect assets will be those options that we do in advance. Now, what is in advance? For example, for Medicaid purposes. For Medicaid purposes, that would be 5 years before needing a nursing home and 2.5 years before needing home health aides. Now, I don't have a crystal ball. If I did, I'd be sitting somewhere warmer where it's not as humid and rainy like it is this summer, right? Maybe sipping on a margarita. But I don't have that crystal ball. We don't know what the future holds. It may be 5 years, it may be 2 years, it may be 7 years before someone needs a nursing home, 10 years. We don't know. We've had clients in their 60s have strokes and need to be in a nursing home. We've had clients in their 90s where he kept telling me for 2 years to get them to get his estate plan done, that he was too young to get it done. And you know what? He's still kicking. It's been 5 years, and he's in assisted living right now. But we did get his estate plan done. So apparently, at 92, it was time for him. I mean, I use that as a drastic illustration, but listen, I mean, we have the opportunity to plan ahead and go ahead and get those things done. I liken it to a chess game, right? So we have options. For example, even where we have someone who's waited until the last minute to do Medicaid planning, like I need to go into a nursing home tomorrow, we can often still save them approximately half of their assets if everything lines up right. So when I say I like it to a chess game, I mean the most advanced planning we can do is doing it early, 5 years before, 2.5 years before needing home health aides, and we have all the moves ahead of us. But if, for example, circumstances change and we don't get past those look back periods, then we can regroup and we have other moves available to us. For example, transferring assets to qualified individuals if we have those people in our circumstances. For example, disabled children that have lived with us, transferring assets to healthy spouses. There's a lot of different strategies that we can use. And from an estate tax planning perspective, the same thing goes with estate tax planning. For example, in New York, there is a clawback of 3 years for assets that you've gifted out. Now, if we don't get past that 3-year window, it doesn't look like we're going to get past that 3-year window, we can always regroup and look at what other strategies we have. So yes, the earlier, the better, the more proactive we can be, the more options we have, and the better likelihood that we can save as much of our money as possible, protecting it for our heirs. But simply because we've waited doesn't mean we don't have that opportunity. It just means that we should act sooner than later to get ahead, and hopefully we can get the same advantages of those cases. So let's talk about our next myth, which will be that you can disinherit anybody that you want. And this often comes up because we often have clients that are married, although been separated for many, many years. And this goes to our first point, in that you can't actually completely disinherit a spouse in New York. A spouse has what's called an elective share. Now, I hope all you are very happy in your marriages, but if you're not, that's okay too. And if you're contemplating not providing for a spouse that you have been married to but's been separated for, we need to talk, because that spouse does have this right. What is an elective share? If you write a will or change your beneficiaries or transfer assets out of your name to avoid having to contribute to that spouse, the spouse has a right to elect a share of 1/3 of your estate. So no matter what, if you don't provide for your spouse or provide less than 1/3, your spouse will have the right to get that 1/3. They have to take the action. They'll file an election with the court. They have to do that within a certain time period. It's on them, essentially, but they do have that right. Now, there's some ways to do some elective share planning. That's what we do. We're estate planners. So that way we can plan to minimize the elective share, or strategically pick what assets will be included as part of the elective share. Now, in second marriage situations, this can be very important, because maybe second marriage, we've been married, we have kids, adult children got divorced, get remarried, and we have our own assets. I have assets from my life, and you have assets from your life. We love each other. We're committed to living out the rest of our lives together. But if I was to pass away, for example, I wouldn't want the money to go to my surviving spouse now that has their own assets. I'd want it to go to my children, because if I leave it to my surviving spouse, there's a good chance then that the assets will go to their children instead of my children, right? We're leaving it up to chance, basically, on saying who dies first. And we really want to have some more control over that. So elective share planning can be very important in a second marriage situation, where we can potentially be waiving the right of election. So that way we know that we are protecting our individual children. And that's fair for both spouses, to make sure that that our children are protected, and not necessarily having funds end up being in someone else's hands and disinheriting our own children. So that's a great segue to another class where it's hard to disinherit somebody. So we often get a client in that wants to disinherit a child. Now, can you disinherit a child? 100%. Absolutely, you can disinherit a child. there's no restriction over that like the elective share. But where we do run into some issues is the logistics of how does that actually happen. And this comes from the probate process, and we're going to talk about that in one of our next slides about what the probate process is. But in the probate process, the child has a right to contest the will. So simply disinheriting a child can present a couple problems. One way of doing it is just not naming the child. By not naming the child, though, you leave the argument for that child to make that it was an accident. Oh, the child was accidentally left off the list of children because we haven't specifically carved them out somehow. We listed all 6 siblings, but not the other 7th one. But somehow it was left out. That's the argument that I'll often take. So we often recommend specifically disinheriting them, even though it says now in the document that we are not leaving an asset to them. But even then, they have a right to contest that. They have a right to be heard over the validity of the will, right? And naturally, when this all happens, you, the person that's created the will, is not going to be here, right? You're not going to be here because you've passed away. These issues don't present themselves during your lifetime. They will present themselves after you pass away. And that's normally a bad stressor for a family, especially a family where there's already been some issues between the children and the parents, right? And so that can be an additional stressor just to push things over the edge. We often find that a child or any beneficiary that would have a right to inherit, we call a distributee. If you leave them nothing at all, you give them nothing to lose and everything to gain. For example, if I have an estate worth $500,000 and I want to leave it all to my one child, I'll pick my oldest for right now. I love them. They're great. Ellie and Lily, I love them. I pick just one of them. I'm going to leave all the $500,000 to Ellie. And let's just figure they're all of age for a second, because I know I told you they're all minors. What'll happen, though, is Lily, who's getting 0, has nothing to lose. So what's the disincentive for her to, you know what, I'm going to give it a shot. I don't exactly know what happened with mom and dad when they did their will. Maybe something happened. Maybe they didn't. Maybe Eliana took them down to the lawyer's office. Maybe Eliana paid for the legal fees. And maybe it was Ellie that guided their hands across the will to get herself named. I just don't know. You know what? I'm contesting. I have nothing to lose. And I can stand to gain $250,000. Why? Because if the will is admitted to probate, Eliana gets $500,000. Lily gets 0. But if the will is denied probate, and now we fall back to administration, which we talked about the state making wishes for you, then 50-50 split. So 50-50, half of the 500,000 is 250. Lily's sitting there going, I got $250,000 to gain and 0 to lose. So that person's a dangerous person, at least in our world, right, to litigate against, because they don't think rationally like most people would have something to lose, and they have to consider that in part of their argument. So one of the things that we will often recommend, and I know it's hard for many clients to stomach the idea because they want to disinherit this child, is to leave something to the child. Leave something to the child, so that way, if they want to contest, then we put what's called a no contest clause in there that says if they contest and they lose, okay, because if they contest and they're right, then obviously that goes out the window. But if they contest and they lose because they're going to say, oh, mom and dad didn't know what they were signing, Eliana forced them to do it, and she's wrong, the court disagrees, the evidence shows that everything was perfect and right, then Lily will lose her distribution. So for example, if I go that same 500,000, I say $100,000 to Lily, $400,000 to Eliana. You know what? I just made things a lot easier, because now Lily's going to have to sit and say, you know what? I have to make the decision between potentially losing $100,000 and gaining $150,000. So now I got to start to weigh those decisions. That's one way we can do it. Another way we can do things like that, I had this discussion with a strategy with a client yesterday, is put the money in the hands of someone that they would have to take the money out of, that they wouldn't want to take the money out of their hands. So let me give you an idea what I'm thinking. For example, let's say I now flash forward 50 years in the future, my kids are older, I have grandkids now. And I say, you know what, I had a falling out with Lily again, right? Want her out. But I don't want to disinherit her completely because of the I knew that this is going to create her with nothing to lose and everything to gain. So it's got a little bit of a problem to it. I know what, I can't stomach giving her even that $100,000. It makes me nauseous to even think about it. So maybe what I'll do is I'll say for that $400,000 to Eliana, and the $100,000 to Lily's children. So now Lily has got to make the decision if she is going to fight this. If she's going to fight this, what's going to happen is she's going to be taking money out of her own children's hands. Now, I don't know if that would motivate her or not. I think it really comes down to a fact, specific case, knowing the people better than anybody else. But that might give her pause about contesting, because now she's taking the money out of people's hands that she loves. She might not like her sister, maybe they got to a fight, but she doesn't want to take it out of her children's hands. And so maybe that's a way we can kind of get around that. Now, this doesn't just go for children. This goes for any distributee. And what a distributee is, those people that would inherit if you didn't have a will. So we always want to be cognizant of who we are, who our distributees are. And if we're not treating them the way they would be treated under the law, that we take a pause to make sure that we aren't creating an incentive to contest the will with nothing to lose. Okay. Now, another one where we see is disinheriting a child for their benefit. Now, where might I want to do that? That might be good in a case where, let's say I have a child who's disabled and they're on government benefits. Let's say they're on Medicaid themselves. They're on disability. Look, these are means-tested programs. If I give that child money through my estate plan, they're going to be knocked off of their benefits. They're going to lose their government benefits. They're going to lose their Medicaid. They're going to lose their disability, because now they're going to have come into this lump sum of money that's well in excess of the minimal amount they're allowed to have. And so when that happens, the planning that child needs to do is then get their own supplemental needs trust, basically do some trust planning to be able to protect the assets. But the caveat, the trick, the devil in the details there is that the beneficiary of that trust needs to be the state of New York. It needs to be the state where they're getting the Medicaid benefits or the disability benefits. And so they need to be named as the beneficiary to basically be reimbursed for any benefits that have been paid out. So for example, if I leave to my two children, half, going back to half, I love them both, 250, but one of them is disabled on government benefits. If I leave the 250 to Lily, let's say she's the one who's disabled. Sorry, Lily, picking on you today. Then what will happen now is that she'd have to put that $250,000 into a trust. And let's say that she only spent, $50,000 of it because it was generating income and she was living off of some of it, but then she passed away. And the state had paid out $300,000 of benefits for her, for Medicaid, for medical, for disability, food stamps, all these different things that if you're not working, you need to get government benefits for. The state's going to claim all of that money as a beneficiary of that trust. That's when the person, the child, the disabled individual, the disabled beneficiary does that planning themselves. But you can plan ahead. And by putting into your estate planning, standby trust, this is what I call them, standby, because we hope they're never needed. But we help people plan for the worst and hope for the best. That's the nature of what we do, not the other way around, not planning for the best and then the worst happens and we were caught unprepared. What we can do is we can put standby trusts in place. So that way, if a beneficiary is disabled, that the money doesn't go to them, that they're disinherited, so to speak, right? So they don't get the money outright, but the money goes to a trust for their benefit, allowing them to have access to money, not being left with nothing, but leaving it behind in a way that lets them get money out of that trust strategically without having the state having to be named as the beneficiary. Because the difference there is if I create that trust as part of my estate plan for Lily, instead of me leaving Lily money, Lily creates that trust. I don't need to have a payback provision. I don't need to name the state as the beneficiary of the trust. And that's a big deal because now that money can be used for my child. And I know that the state can't ever come after it. Another way we also do this is we will sometimes put trust in place for minors. And this is another one of those standby trusts that we put in place where we will have, look, my 18-year-olds, my younger than 18-year-olds, right? We don't want them inheriting money because if they do, they have to go through those court proceedings to get access to the money. But that's one problem. The second problem is now the money to be spent needs to be done under court supervision. And when it's done under the court supervision, it needs to be done very, very conservatively. The state's goal there, because they supervise every expenditure, is to make sure that the money is there for when the child turns age 18. which means they're going to be very conservative in the distributions. And then when this child turns age 18, they're going to get an outright distribution of all the money. So for example, 250,000, 250,000 at each one of my children. My wife and I both passed away. What happens? They're both 6 and 4 right now. Both going to have to go through a court proceeding, both conservative. Now, I would have been conservative with my money. I would have sent them to camp, right? That's the goal for them. I'm conservative in other places so I can spend it on my children. The court's not going to say, great, send them to camp. That's not the tough luck. That's not their beat that they have to now pay for their camp, right? They're going to pay for things like if they're going to get thrown out in the street or they have no food, but they're otherwise going to want to preserve that money. And those serious concerns about the child's well-being, and really the only time where the court's going to allow those monies. But I can control that by having put these standby trusts inside of my estate plan. The other place we can deal with these things in terms of disinheriting a child would be where we have concern about a child who's got creditor problems and spending problems, where if we give them money outright, then they're going to get that money and they're going to blow it. They're going to blow it. They're going to get a lien filed against them. Maybe they already have lien filed against them. So it's just going to go to some creditors. Maybe they're in a high-risk profession like doctors, subject to malpractice, police officers, right? With everything that's going on in the current landscape. I hear that come up a lot. And then also where we have an issue with maybe we're concerned that it will end up in the in-laws' hands. So for example, if child passes away and leaves a will leaving it to spouse, now spouse, who's not my child, ends up with the money. Now I think that's a little different if everybody's older, potentially. Certainly a problem, I think, when they were in our 30s, 40s, 50s, because that we would love for that person to potentially get remarried, but I wouldn't want that person now, that new spouse, to end up with money. I want to be able to control that money, even though I am passed away. And you can do that by leaving money behind for your children in trust. Now, technically, it would be disinheriting them, but no, not really, because they're going to end up with the money in a trust for themselves, and that way it protects it to keep it within the family. People would rather have that money than go to their grandchildren rather than get outside of the bloodline, so to speak. So these are just strategies that we can do to help protect. And so you can and cannot disinherit anyone you choose, right? We know we can't disinherit that spouse. It will, there's a potential that the spouse will get 1/3. We do need to do some right of elective share planning to make sure that happens. And simply disinheriting other interested heirs like the children, if that was the case, becomes problematic. Can be done, needs to be done thoughtfully, needs to be done potentially utilizing a trust so we can avoid probate, which is a great way to segue to our next myth, which is that wills avoid probate. I hear this all the time. People will say, wait a second, I'm preparing my will, so now I've avoided probate. Isn't that right? The answer is no. It's actually the opposite. A will forces probate. Now let's just talk about what probate is, and you'll understand exactly why. Probate is the process where we have to go to court. Now, this is not you when I say we, this is the executor, the person you've named in your documents to carry out these wishes, needs to go to court and prove the validity of the will. You have to prove that you had capacity, that it was properly signed, that all the formalities were met, that this was of your free will, no one forced you to do it, you were healthy and good sound mind at the time it was done. This is a whole process that needs to happen, even if no one wants to contest the estate. You still have to prove the will is valid. You still have to go through the probate process. And what it leaves you doing is reliant on the court system to get your assets to your beneficiaries. Now, I'll give you an example. Last year during COVID, the surrogates court, the court that hears these probate proceedings, was closed. It was closed for like 3 months, and then they reopened up and they were backlogged, and no one could get access to assets through wills until the court was fully up to speed and issued what's called letters testamentary. And I'll give you an example. We saw this scenario play out numerous ways with clients or people who came to us during that time period where we hadn't done the planning. House. Last year, the market was on fire, and it's kind of, still up there, but coming down a little bit. But last year was on fire, right? People wanted to sell a house in March of last year to get, capitalize on the rush of people coming out from the city. People that had their house in their names and had a will to take care of transferring the asset to the beneficiaries, weren't able to sell the house. Why? Because after they passed away, no one was authorized to sell the house. The person who would be authorized to sell the house would be the executor. And the executor isn't actually appointed until the court approves the will through the probate proceeding and issues those letters testamentary. And when that happens, then the house can be sold. But people who instead avoided probate, and we'll talk about some different ways of avoiding probate, but one of the common ways is to prepare a trust. And those people that waited, or those people that had trusts, even if they only held a piece of real estate, the trustees were able to sell houses right away. They had immediate access to the money, immediate control, no gap in control of the asset. And this is because trusts don't need to be proven to be valid. They need to be proven to be invalid, right? So it goes the other way around. It puts the burden all the other way around, right? It puts the burden that if someone wants to contest the trust, by all means, they can contest the trust. But it's not like we have to prove the validity of the trust to even get the trust to work. And that's the way that the will works. And that's what the probate proceeding is. So when we understand it like that, by utilizing a will as the primary transfer vehicle for our assets from one generation to the next, from your name to your beneficiaries, what happens is it needs to go through the court. Now, so what do you say? What is the point of a will then? The point of the will is going back to our discussion above about making our wishes known. You're choosing your beneficiaries. You're choosing your beneficiaries, and you're choosing who's in charge of taking care of the asset transfer, who is the executor, right? If you don't make those elections, the state's got default beneficiaries for you. They're called distributees. And they're also called, and it also gets to pick for you what the person that's instead of an executor, it's called an administrator. So the state's picking the person who would be able to be in charge of taking care of the assets. So by doing a will, it's a great step. It's an essential piece of an estate plan, 100% a foundational piece, but it's not where we should stop if we're concerned about probate. So probate can, create some problems. One is that's the court proceeding, the length, the time, the delay. It's also public. So we have to file this will with the court. We also have to file a list of your assets, your family's information, addresses, dates of birth. Everything gets filed with the court that anybody could go walk into and get that information out of the court record. They'll know all your assets, your whole family information, and what your will said. Trusts remain private, and we don't necessarily need to do that unless we have to go through a court proceeding, and then we can always ask to have it sealed. The other thing is going back to distributing assets and disinheriting. If we disinherit someone through a will versus a trust, there can be a big difference. And this goes back again to making it more difficult for those disinherited people to contest. A trust makes it more difficult. And why is that? That's because in order to even move forward with the will, you need to get every interested party to sign off approving of the will or serve them with a citation, a summons, a piece of paper telling them to come to court to contest the will. You have to dangle it in front of them and say, here's your day in court, or here, sign this thing and waive your day in court. But if you don't do either one of those, we got to go to court and we got to wait on that. And we got to wait for a court date. I'm going to give you an example of a client we're working with right now that they did estate planning many, many years ago. We didn't help with that estate plan, but they came to us to help with the estate administration. Everything for the most part was taken care of in one of the other ways that we're going to talk about avoiding probate in the next slide. But what happened in this case, one asset was in the person who passed away in their sole name. Now, it was a married couple, wife still alive, husband passed away. Husband and wife had two joint children, so two children together, but husband had one child that was outside of the marriage, so not the wife's child. Also, husband and wife had a child who died very young, who was about 20-something years old, but he had two children who they don't really have a relationship with, these two grandchildren. So now, when we looked at this estate, the stepchild, which mom has no relationship with, and the grandchildren, which mom didn't have children with, or didn't have a relationship with, are all interested in the estate proceeding. The will, though, leaves everything to the wife. Naturally, why wouldn't it? Husband leaves to wife, wife leaves to husband. But we have not, even to this point yet, it's been about 18 months, have not been able to probate that will yet because the sister-in-law and the two grandchildren are contesting. Now, I didn't execute the will or defending that will. I don't see any reason why that will was invalid at this juncture in the litigation. it was prepared properly, it was supervised by an attorney, the person had capacity, but we still need to go through this proceeding, and they're dragging it out, I would imagine, in the hope that we settle through a settlement, right? And they get something. Now, it would have been harder with a trust. Sure, they could have contested, but one, we wouldn't have had to even notify them of the death. We wouldn't have had to track them down like we did. We had to do some background investigations and track them down. We wouldn't have had to find them, serve them, notify them, give them a day to come and create this ruckus, right? They would have had to do all of that on their own. And so that would have made it a lot harder. And we would have been able to actually take care of the transfer already. They probably got here too late by the time they even figured it out. And so that's one of the inherent problems with probate. So how do we avoid probate? One of the most common ways you can do is to hold things in what we call joint tenancy. Now, this really works very nice with husband and wife because we can have joint owners on it. And what happens is when one person passes away, like that piece of real estate with that husband and wife, if it had been held in joint ownership with a right of survivorship instead of the way it was held, which was just in one person's name, it would pass automatically to this surviving joint owner. No need to go to court. Actually, even no trust needed. That can work great for husband and wife, can certainly work great for when the first spouse passes away. But when the second spouse passes away, we run into some problems there because we don't necessarily want to put our children on or our beneficiaries on as present owners of our property, because then we lose our rights to that property. We used to have 100% outright ownership. And when we put them on, we lose that 100% outright ownership. And that can have some negative effects. For example, with real estate, you could lose your exclusive right of occupancy. And when you lose your exclusive right of occupancy, you lose your property tax exemptions, you lose your capital gains benefits, you lose your bankruptcy benefits, lots of things you get lost. And it also makes it hard to change, because if you ever wanted to change your estate plan in the future, right? But if you have now put as part of the estate plan a beneficiary on as the joint owner, you're going to need them to sign off on their disinheritance, which becomes a huge problem because who's going to sign off on their own disinheritance? That doesn't make any sense. Another way is bank accounts with payable on death beneficiary designations. These are great things with for like estate planning 101. If I have a small little account I want to do on payable on death, where it doesn't quite make sense to go through some trust planning. But the problems with these is that it doesn't allow you to do any of those special planning options we talked about, like planning for minors, planning for disabled beneficiaries, planning for the what ifs. Like if I name payable on death beneficiary, maybe I name one or two, but what happens if one and two both pass away and I haven't named a third on there because it didn't give me an option at that bank? I could have addressed that in a lot greater detail in a trust. A real estate transfer with an on death designation, what we call is a life estate. There's really no way to list the beneficiary on there, but we call a life estate. This is another way of doing this, but the problem we find with clients that don't like that option is it's irrevocable, much like I talked about putting a joint owner on the account, that they can't get that back. I had a potential client come in here. Ultimately, we weren't able to help them. Again, they hadn't come to us first. They had tried doing a solution on their own about 10 years ago, came to us, said, we want to change our estate plan. We want to disinherit one of our daughters. How do we do that? I said, let me see the deed. That was their major asset. And they had already put a life estate, a transfer on death, so to speak, right on the real estate. So what happened there was we needed that daughter to sign off returning that interest back to mom and dad, which of course she never did. She probably took that letter we sent to her, crumpled it up and threw it in the garbage, right? Because why would she voluntarily give it back all that money when she doesn't need to? And what's worse is that if those clients ever want to sell their property in the future, they'll have to contribute a portion of those proceeds, even while they're still alive, to that child who they want nothing to do with. It's very common, though, to have on your IRA accounts, your investment accounts, life insurance policies, designated beneficiaries, and those things will avoid probate. But as a matter of estate planning, not necessarily the best way of structuring things, because it's dealing with everything piecemeal. So you could have this account with these beneficiaries, want to change it, but then forget to make the change on the other account that you wanted to change. So once we get to the level of planning like we do for Medicaid planning, is to utilize a trust, then I start to recommend making the trust the beneficiary. It'll still avoid probate, but we can kind of filter everything through that trust, making things as easy as possible. Which brings us to our last myth, which is that trusts avoid estate taxes and also help protect assets from Medicaid. Now, this is a partial truth and a partial myth. And this is why it's dangerous, because not all trusts are created the same. We often hear from clients that there's only two types of trusts, right? Revocable and irrevocable, right? And one of the biggest myths that we hear is those are the only types and those are my choices. And the answer is really not really the case. Yes, there are revocable trusts, there are irrevocable trusts, but those are largely irrelevant, right? And the reason is because an irrevocable trust is still revocable. It's just a different way of revoking it. So when you have a revocable trust, the person that created the trust can revoke it themselves. But where you have an irrevocable trust, there's some other key holders that are needed. Those other key holders are the beneficiaries and the trustees. Now, it's very common, though, in an irrevocable trust to name the trustees and the beneficiaries and to retain a right to change the trustees and the beneficiaries. So let me just take that back for a second. If you're saying to terminate the trust, you need two key holders, the trustees and the beneficiaries, but I get to pick who has those keys and I can change that at any time without anybody's approval with all I ever want, whenever I want to do it, then you get to pick who gets to hold the keys. So you then have the ability to revoke that trust. If we go with, like, think about it as a fail-safe from nuclear weapons, if I have 3 keys that need to be used to initiate the launch, but I get to pick and choose who gets those keys, and someone doesn't want to listen to me, and then I just give the key to somebody else. And so that's the idea here. We can revoke those trusts. The trusts need to be prepared specifically for the goal that you want, though. For example, a revocable trust often will only ever provide protection from probate. It can provide some minimal Medicaid protection for specific assets, but not most assets, not all assets. And even irrevocable trusts, which is commonly the ones that we see people know about for Medicaid planning or tax planning, will not work for those intended purposes unless the terms of the trust are prepared in a way so that they accomplish those objectives, such as protecting the asset from Medicaid, such as reducing the estate taxes by removing them from the taxable estate. If the right provisions are not there, a trust that you think is doing something for you, because someone said that, is not going to actually accomplish those goals. So what matters here the most is developing a strategy to make sure that those estate taxes, those Medicaid planning, those objectives are accomplished and done in a way that allows you to be comfortable, but accomplishes those future goals, but make sure that the actual terms of the trust will accomplish what you want. Because we know now that just having an irrevocable trust, for example, will not automatically protect your assets from Medicaid, because certain provisions need to be in that type of trust. Just having that irrevocable trust that protects assets from Medicaid will not remove those assets from your estate tax perspective, because it doesn't have the right provisions in there. So we need to make sure we get that right. So there's a lot. We tackled a lot of myths, and really what it comes down to is really protecting your legacy and coming up with a strategy that fits your needs, right? So look at this like building an estate plan, right? Is like building a house. No one would just go out there, go down to Home Depot, buy a whole bunch of crap, go drive it down there and start building. No, you would start with a plan. You would start by sitting with an architect. You'd start by sitting with a designer to figure out where the walls are going to go. Are we going to have 3 bedrooms? Are we going to have 2 bedrooms? Are we going to have 3 baths? Or are we going to have 2.5 baths? Are we going to have a modern look to the house or a colonial look to the house? Are we going to have granite countertop, or are we going to have Formica? We need to be able to plan these things. Sure, a house is a house, just like an estate plan is an estate plan. But we got to come up with the strategy that fits for you. So what we have as an option for you is a strategy session to protect your legacy. This will give us the ability to sit down one-on-one with you, give you more tailored advice, taking some of these myths and seeing how they fit into your family situation and your asset situation, and coming up with a plan that can help accomplish your goals of protecting your legacy. This is for you if you have a family, if you've worked hard for money and you want to protect that money for your family. You want to be able to leave that money to your children instead of leaving that money to the government through taxes or through Medicaid. So how does this work? This would be a 1-hour meeting. We can offer it virtual or in person. I find it very helpful to be in person, but we do have virtual as an option for those that you feel comfortable. And in that meeting, we will discuss first your desired objectives, because if we don't talk about the end goal, if we don't talk about where we're going, we don't have a compass putting us in that direction, how will we even know what steps to take? So we're going to take that now, once we have that compass point, and once we have that desired legacy you're looking to provide, what your objectives are, we'll help you explore the best asset protection plans for you. We talked about the myths today. Now, the biggest myth was that what someone says doesn't necessarily mean that this fits for me. That's a big problem. So we need to make sure that it fits for you and your family, and for your tolerances and what you want in your estate and what you want to have happen. It'll help you tackle some difficult issues that you've been procrastinating on. Look, nobody wants to deal with these things, but we know it needs to get done. So it's that thing that's nagging at us. It's that thing that's in the closet. That's why we have us at 70, 75, 80, my 90-year-old clients, right, that are just coming in to do their estate plan because they've procrastinated. Okay, so it's uncomfortable. Let us help you take that uncomfortability out of it and move you forward. And we'll answer any of the questions that you have about your unique situation. After I'm done with this, we're going to do the Q&A, but please don't put any specific confidential information into there. I will be glad to answer the questions, but we want to be able to preserve your confidentiality. So at the end of that time together, you will walk away with your options. You'll know what options you have. It may be 1, 2, 3, it might be 4. You might have options. And I'm never in place here to tell you what to do. We help you advise about your options, tell you the pros and cons about your choices, and let you make the direction of your objectives, your desires, and your legacy. We'll give you information about what to do next, right? You'll actually walk away with a plan, not an estate plan, but a plans, right? The blueprint, right? And you can either implement that yourself, or you can hire us to implement the plan for you. Now, typically we charge $450 for these strategy sessions, but for those that are on the webinar today that booked this session, we will discount that to $350. Again, I guarantee that you will find 100% and 110% value in this. You will know your options. You will have an actionable plan to protect your family. And I will give you a money back guarantee on that. That if you walk away from this and you do not feel that you got your questions answered, you did not have an actionable plan that you could work with, I will give you that $350 back. Now, we only have a limited amount of these sessions coming up, and what you can do is you can go ahead and scan that barcode. It's a QR code. You can utilize your phone if you take that out and look at the camera, put the camera on that QR code, and you can scan that. It'll bring you to the scheduling link that you can use to reserve your spot, or you can go to that website there, www.startplanningnow.com. Also, for those that book today, we will give you a $10 Starbucks gift card as a bonus for doing that. You can go ahead to that link. So let's open up the chat here for Q&A. I'm going to leave that link up there for you. And so let's see, Courtney, do we have any questions in the Q&A? If you have questions, now would be a good time to put them in. I'd like to dedicate a few moments to answering your questions. I'll give you a few seconds.
Feel free to put any questions in the chat. Once again, just don't put any personal information in the chat. That's best for a one-on-one session. So the first question that I see here is, if you already have a plan, or I guess this is someone mentioning a myth that they heard, if you already have a plan, there's no need to update it.
Yeah, so that's a really good question, and that's a big myth. And the reason is because maybe yes, maybe no. And how would we know until we looked at it? I think, what I recommend is looking at it every 3 to 5 years. All right, to take a look at it at the most, because there's a lot changing in the law. There's a lot changing in your lives that might change your opportunities that are presented to you. For example, a simple change in the law can present a lot of planning opportunities to get ahead of it. For example, just in October, the state changed look-back periods for community Medicaid. That created a lot of planning opportunities for clients that had revocable trusts, for example, that weren't quite ready to do Medicaid planning, were on the fence. But then knowing this was enough to put them over the edge. Now, we reached out to those people that we had within our network to let them know, hey, there's a significant planning opportunity coming up. But the state's not doing that for you. The state is not going to you and saying, oh, hey, Joe, just giving you a red bulletin alert, like we're changing a law tomorrow and you should get your estate plan re-looked at. It doesn't happen that way. The other thing is, for example, we just had to change the power of attorney on June 13th to a new power of attorney form. Now, those power of attorneys that you have are not necessarily invalid, but what we know, though, is the new formatting is going to make it so that banks, institutions are used to looking at a new power of attorney, and so it looks completely different, and they are likely to be unnecessarily rejecting those old powers of attorney. So it's not that you need to, it's a matter of just being more proactive in planning the way you look at it. If you look at it like set it and forget it, then no, right? Then you don't need to do that. But you're also leaving options on the table. You're leaving it up to whatever you set forth in motion when you did the will, for example, 10 years ago. And that may not reflect what you want today. And so we take more of the approach that this should be looked at. Maybe there's not changes that need to be made, but at least should be reviewed to make sure, like a checkup, like you go to the doctor for a physical. Now you go every single year, but you certainly don't go 10 years down the road and go like, yeah, I got a physical 10 years ago, everything was good, right? You got to get it checked up. And so maybe there's no changes that need to be made, but maybe there are. Maybe there's been a death in the family. Maybe there's been a marriage that's changed things. What if you don't exactly understand how these changing circumstances actually impact your plan? Because you'd need to pull out your trust and read it, right? And see how that impacts your plan and make sure that you understand exactly that. So we find that if we look at it every 3 to 5 years, so half the clients are making changes, half the clients are taking the strategic opportunities that present themselves, and some are perfectly okay with just leaving it as it is, but they're making that decision to do so.
Perfect. So once again, you can put any questions in the chat. There is another one here, another myth that's mentioned. If you're married, you don't need an estate plan because all the money will just go to the spouse. And I think we touched on this earlier as far as the—
Sure, that's a great question. And just like all of the other myths, it can and cannot work. It just depends on what it is you're looking for. It's very common in a first marriage, the only time we've ever been married, all the children are from one marriage, right? So we don't have children outside of the marriage. If everything's held with joint ownership and beneficiaries pointed to the spouses, it can avoid probate upon the death of the first spouse. But there's some reasons why we might not want that to happen. For example, one would be, what if that spouse was on disability or on Medicaid? This is common when we're dealing with elderly clients. We're dealing with seniors. We may be doing Medicaid planning for one. Maybe one's on Medicaid. And yes, if everything is named in beneficiary to the surviving spouse, that can work from avoiding probate, but it will now make that spouse ineligible for Medicaid. Maybe we could have done something different that could have avoided probate, but kept those assets out of their Medicaid estate, so to speak, to keep them protected and out of the state's hands. That's one level. And so with the spouse, yes, if we're not worried about those other things that can pop up like that, right? Simply avoiding probate, just having joint ownership can work very nicely. But where that becomes a problem, where a trust can go just a bit further, and I've seen this happen a lot. This is where two spouses pass away either simultaneously or relatively close together without ever having changed their estate plan and updated it upon the death of that one of those spouses, or where it's been years and sometimes people still don't. You mentioned, for example, do we need to update the estate plan? I did it 10 years ago. Well, if a spouse died, yeah, we should, because now when we want assets to go to the beneficiaries, right, to go to our children, simply the way they sit now is not going to provide that probate protection, right? And so the monies will have to go through probate and we have to set up one of those methods that we talked about earlier, which will allow it to avoid probate. We've had, unfortunately, happened a lot during COVID where two spouses passed away really quickly. One spouse passed away, but now everything became the surviving spouse's asset. Then they passed away a month later. Naturally, they were sick. They had COVID, right? They never got into the office to change their plan now at this point. And so what happened with those assets, we had to bring two estate proceedings, even though both the spouses had passed away. And we really, seems like we should only have to deal with one. We had to do one estate proceeding for the first spouse to die to be able to transfer the assets, do a second estate proceeding to transfer the trust, And then it just became a big mess, right? So that's where we can get in a trust, can avoid some of those things, because even though, yes, joint ownership is like 101 level of getting these estate plans done, doesn't plan for everything. And in the trust, it can provide for these successive steps without ever having to go through a court proceeding.
Great, thank you. Again, if you have any specific questions, I highly encourage a one-on-one discussion to develop a strategy for your specific situation. That seems to be the questions that everyone has, but of course, if you have additional questions, it can be addressed in the consultation. You can use the link, the website www.startplanningnow.com. You can scan the QR code as well, or if it's easiest, you can give me a call. I put the number in the chat, and you can give me a call to schedule the consultation, and we can set that up for you.
Very good. Thank you, everybody, for attending today. I hope you found the content to be very helpful, and we'll keep generating more content for you just like this. Everybody be well. Enjoy the rest of your afternoons, and we'll see you soon.
Thank you, everyone.